This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why Mr. Tinkle, as the authorized representative of a company called Westlake, and stole as that authorized representative more than $16 million. Westlake Chemical Corporation tendered claims to Berkley Regional Insurance Company and Zurich American Insurance Company, seeking coverage for $16 million in losses resulting from the payment of fraudulent invoices for shipping bags used to export Westlake's products. After a dispute arose among the parties regarding coverage for the tendered claims, Westlake sued the insurers for breach of contract, violations of the Texas Insurance Code, and declaratory relief. The trial court granted summary judgment in favor of the insurers, and the decision was appealed in a case called Westlake versus Berkley and Zurich, a Court of Appeals of Texas decision dated May 25, 2023. Westlake argued the trial court erred in its granting summary judgment in favor of the insurers. In two issues, Westlake argued the trial court erred by finding that, one, its loss was not covered by the insurance policy's computer fraud clause, and two, the insurance policy contained an exclusion that barred coverage for its loss. Westlake manufactures polyethylene and polyvinyl chloride products, which it sells internationally. From 2007 until 2014, Westlake purchased plastic shipping bags and other supplies to export its products from John Tinkle through his company Tinkle Management Inc, TMI, a supplier of shipping bags to chemical companies. TMI delivered Westlake's plastic shipping bags to a warehouse owned by Packwell Inc., a plastic bagging and logistic company, and Packwell used the supplies to package and ship Westlake's chemical products overseas. After the shipping supplies were delivered by TMI, Tinkle would submit an invoice to Westlake for payment of the supplies. From March 2010 until October 2014, the appropriately named Tinkle submitted fraudulent invoices and supporting documentation to Westlake via email for fictitious bags that were never delivered to Packwell. Relying on the false invoices and shipping reports, Westlake paid Tinkle $16,423,941.78 for shipping bags that Tinkle never provided. Westlake did not discover Tinkle's fraud until October 23, 2014. In April of 2017, Tinkle pleaded guilty and was sentenced to 48 months in prison in order to pay restitution to Westlake in the amount of $15,633,403.98. Westlake purchased a commercial crime policy from Berkley that provided coverage of $10 million for each occurrence of computer fraud, and a crime insurance excess policy from Zurich that provided Westlake an additional $5 million in coverage. Berkley promised to pay for loss or damage to money, securities, and other property resulting directly from the use of any computer to fraudulently cause a transfer of that property from inside the premises or banking premises to a person other than a messenger outside those premises or to a place outside those premises. The Zurich policy's insuring clause was excess of the Berkley policy. In no event shall coverage under the Zurich policy be broader than coverage under the Berkley policy, and after Westlake discovered Tinkle's fraud, in October 2014, Westlake tendered timely notice of its discovery and proof of loss statements to Berkley and Zurich. Yet on October 25, 2016, Berkley denied coverage for Westlake's loss under the Berkley policy because the loss did not result directly from the use of a computer and because it resulted from a dishonest act by an authorized representative of Westlake, Tinkle. The parties do not dispute that Westlake's loss is not covered by the Zurich policy unless the Berkley policy also covers the loss. The trial court ordered that Westlake take nothing on its claims against the insurers. Since an insured has the initial burden of establishing coverage under the insurance policy, it is only after it does so that the insurer can then be called upon to prove an exclusion applies. The court concluded that the insurers carried their burden to prove that coverage is excluded under the policy. The insurers argued that Tinkle was Westlake's authorized representative, and thus, whether or not the loss originated from computer fraud, Westlake's loss is excluded from coverage based on the policy, which excludes coverage for acts of employees, managers, directors, trustees, or representatives. Given the dictionary definition of the phrase authorized representative, it can commonly be understood to mean someone who has permission to act or speak for another, and someone who is empowered to act on behalf of another's. Nothing in the Berkley policy indicates that the phrase authorized representative was intended to have a technical or legal definition, and therefore the court concluded that Tinkle was Westlake's authorized representative. Based on the plain meaning of authorized representative, the insurers were entitled to summary judgment. As part of its summary judgment evidence, the insurers submitted deposition testimony from Westlake's corporate representative, Christopher Anderson, Westlake's interrogatory responses, and a letter from Westlake responding to Berkley's questions about Westlake's loss prepared as part of the claims process. Relying on these exhibits, the insurers argued that Westlake admitted that Tinkle was an authorized representative because Westlake admitted that it empowered Tinkle to act on its behalf. Anderson's testimony, Westlake's interrogatory responses, and its letter to Berkley demonstrate that Westlake authorized Tinkle to manage its shipping supplies, to order additional shipping bags for Westlake, and to ensure that Westlake received the ordered inventory. Based on the plain meaning of the term authorized representative, the insurers had to conclusively establish that Tinkle had permission to or was otherwise empowered to act on Westlake's behalf. The court concluded that Anderson's uncontradicted testimony that Westlake outsourced responsibility to Tinkle to ensure that Westlake was receiving necessary inventory was enough to satisfy the insurer's burden. In my opinion, insurance covers many risks of loss, but no insurance policy covers every possible risk of loss. Westlake trusted its supplier, Tinkle, to act on its behalf and deliver necessary shipping materials for Westlake to deliver its products to its customer. It was cheated by someone it trusted and who acted on its behalf. They didn't monitor what was being sold, what was being purchased, what was being delivered, and they have very few people to blame other than themselves and Mr. Tinkle. The exclusion was clear and unambiguous, and no matter how much Tinkle overcharged, it did so with authority, and that was clearly and unambiguously excluded. Westlake's only hope now is to recover on the restitution order, which will probably be difficult since Mr. Tinkle will find it difficult to pay on what he earns as a prisoner in a state or federal prison. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog, and you can subscribe to the blog. And if you like it, and you like the videos on Rumble and on YouTube, please click on the like buttons, and for Rumble, the thumbs up button. And tell your friends and colleagues so that they can also subscribe to the blog and view the more than 4,500 blog postings and the many hundreds of videos available. And if you want further detail and further detailed insurance law discussions, you might consider, for a small fee, subscribing to my Locals Community or my Substack publications. Thank you for your attention.